Good morning. I'm Cecilia Zalkind. I'm the Executive Director of the Association for Children of New Jersey, one of the co-sponsors of this forum. Welcome. It's very exciting to see the interest and the breadth of experience in this room. We're looking forward to a very lively presentation from the panel and then discussion through a question and answer from the audience. Before I begin, I just really want to commend again Elizabeth Donahue and Mary Coogan from our office for putting together this panel. ACNJ is celebrating its 30th anniversary this year, and we started focused on child welfare and juvenile justice issues, so it's very exciting for us to be involved in this great program today. Thank you. I'm going to begin by introducing all three panelists. Each of them are going to do a presentation for about 15 minutes, and then when they're 15 to 20 minutes, and when their presentations are done, I'm going to ask you to hold your questions and comments till then, and then we'll engage in a discussion with the group. I think this is a particularly exciting topic to begin this forum with because the issue of youth in multiple systems, I think, is not a new one. And again, looking around this room, I see people who represent kids involved with children in every aspect of the system. And we know from our experience that children who have some similar needs wind up with different treatment depending on what system door they enter. And that coordinating those systems across mental health, child welfare, education, and juvenile justice are often very difficult and challenging. So I think we have an exciting panel here today who is going to discuss those issues. Our first speaker will be Robert Schwartz. I've known Bob for a long time. He is the director of the Juvenile Law Center in Philadelphia. He co-founded the center in 1975 and has been the executive director since 1982. And Bob has, I think, a very exciting background in direct representation, litigation, policy advocacy. He's a wonderful advocate on the state and on the federal level. I'm going to give very brief introductions. The full biographies are in the materials in your packet. The second speaker is Joseph Ryan, who's an assistant professor at the University of Illinois. He's the chair of the child welfare specialization there, and his focus is on the intersection of juvenile justice and child welfare. And our final speaker of the panel will be Thomas Grisso, who is the director of law and psychiatry program at the University of Massachusetts Medical School. And he has done extensive work on forensic evaluation of juveniles for the court and a particular issue of juveniles in the juvenile justice system with mental disorders. Again, I think we have a panel that represents a very exciting mix of experience as well as policy expertise. So let me start with Bob Schwartz.
Thanks, Ceil. It's great to be here, and I've never drunk from a plastic Princeton cup before, so I'm hoping that I can keep this as a souvenir.
I'll give you a clean
for
one.
the day. I'm going to be giving an overview of some multi-system issues with Joe and Tom going much deeper. I'll be doing some issue spotting since I specialize in shallow overviews. I'm not a researcher. But I thought I would start with a case example from a call we had a few years back at Juvenile Law Center in Philadelphia. A 14-year-old boy, Billy, who was actually an orphan. Both parents were dead. He was sent to a residential treatment facility in a suburban county as a dependent child. He didn't have any parents. This was a therapeutic facility because he had a lot of emotional problems following the death of his parents. He was sent to an intermediate unit for special education testing where he freaked out, threw some furniture around the room, and ran away. He was picked up and arrested for the vandalism in the suburban county, where he was adjudicated delinquent for that. The dependency facility was in an area zoned only for child welfare services and could not take him back. So he ended up back in the juvenile detention center in Philadelphia for disposition as a delinquent youth. This was a system, this was a kid for whom any one of four systems might have been appropriate. The special education system, mental health, child welfare, maybe even juvenile justice system. But the way things work for us is that of those four systems, juvenile justice is trump. If it wants a kid, it gets the kid and keeps him as well. Billy represented the situation that was described for me many years ago by a mental health specialist in Florida who said that kids are sorted into these systems, as Seal mentioned, by virtue of being deemed to be bad, sad, mad, or can't add. They get channeled by virtue of the conduct or characteristics of themselves or their parents. What they've done or who they are, what their parents have done, who their parents are. And while that can be a useful starting point or guide, it's too often a sorting system of convenience for systems to both sort of dump kids and redefine them, and it is an inadequate way to match kids to the right system. And it's too often, I would say, a function of circumstance. It's not purely random, but it's more random for too many kids than it ought to be. And the sorting of these kids into these systems is rarely done by asking for the youth who are eligible for more than one system, what is the purpose of the system? What are we trying to accomplish by using the JJ system as opposed to child welfare or mental health or special education? Or putting it another way, why do we use the juvenile justice system at all for these youth? What do we expect it to deliver in terms of services or risk management or serving public policy goals that the other systems cannot? These issues arise in many ways, and you'll hear a lot more about the child welfare population. I just mentioned that I don't know if you'll be talking about the Midwest study of adult functioning of former foster youth, but this is a longitudinal study out of Chapin Hall which excluded youth who were developmentally disabled, who had serious mental health problems, found prevalence rates of special education much higher for the foster youth than for kids in the general population. A significant percentage of these foster youth were arrested as well while they were in care. And who does the sorting? While it's police on the street, to be sure, many more kids are sorted by we professionals, the child welfare agencies, educators, school administrators, mental health professionals who believe that the juvenile justice system can serve a number of purposes, such as getting kids to behave in ways that the treatment could not. I think that the juvenile court ought to be a better gatekeeper for these referrals. Was always trying to figure out who should be the gatekeeper. We spoke out of our office with police departments around the state. Police don't like making judgments when they get a phone call from a school or a residential treatment facility or a group home. They see themselves as being more like, as one policeman said, like a plumber. I hate to reference plumbers, these days. But once I get a call, I show up, I take the kid. I'm not in the business of deciding whether the kid was culpable in a way that matters. Somebody else has already made that determination. But the juvenile court and its probation staff can certainly make judgments about whether the referral is a valid one, whether or not valid uses of the delinquency system in terms of public safety and when it's used for kids who are more serious offenders who need the JJ system supervision and treatment are appropriate. But they also ought to realize that there are some kids who cannot be deterred or will not necessarily benefit from being in the system, and similar kids are not going to be deterred by what happens to their peers, say in the special education classroom. We've had some judges in some communities around the country throw cases out when referrals of special education have come their way, when kids have acted the way they're supposed to expected to act, and where behavior management plans that are supposed to be parts of individual education programs have not been followed. But judges rarely actually do that. We had a case in our office a couple of years ago of a 12-year-old autistic youth who freaked out when he was touched and was then charged with assault of the substitute special education teacher and adjudicated delinquent and sent away. This was largely involuntary behavior. It'd be like hitting somebody on the kneecap and then arresting them for kicking. You know, but this happens far more frequently than it should. Dependent youth with mental health problems who are in residential treatment programs. We've had numerous clients who have behaved in a way that the treatment facility expected when it put itself out for a contract with the local county. We can take these kids, we can help, we serve them, our program will work, and then when the youth hits a staff person or another youth, the intervention is primarily through the juvenile justice system. So we should have a system in which juvenile courts can be gatekeepers, cannot allow systems to drop kids off at their door. The juvenile court ought to, in these circumstances, have jurisdiction over those systems. Some states have experimented with this, giving courts jurisdiction over education or child welfare or other public service systems that serve kids, but they haven't been very effective. Juvenile courts have been unwilling to act. Another way that the overlap comes up is through the use of detention. And I think this was mentioned earlier as well. When a foster youth is arrested, especially for behavior, say in the group home or foster home, the adult caretaker rarely comes to the detention center to take the kid back. After all, they were the referral source. So who comes for these youth? What are the expectations of the children and youth agencies that have custody of them? These kids are much more likely to penetrate the system more deeply merely by the fact of detention. They're in placement, they don't have a chance to prepare for defenses, they can't show the judge that they could behave in the community, and there are certainly sort of issues when we're detaining these kids who are referred from the child welfare, mental health, or special education system. There are other ways that dual status kids or multi-system kids raise issues for the juvenile court and juvenile justice system. One is the issue of whether or not there should be different kinds of defenses at trial that the law creates that defense attorneys can raise. Something like the manifestation defense in special education, that when kids behave the way they're expected to behave in mental health facilities or special education programs, that should go to the issue of culpability or even the degree of guilt or whether there is guilt at all. Judges ought to have the statutory opportunity to adjudicate these kids dependent or enter something other than a delinquency adjudication, or something that I think of as the Officer Krupke approach to jurisprudence. Unfortunately, that's not been codified since Stephen Sondheim wrote the lyrics. What about youth who are appropriately in the juvenile justice system? The court must have access to mental health and child welfare services as well. There are systems that have a full array of child welfare and other services available to delinquency courts, but they're not, those are rarely fully formed systems. And this really matters, especially when you have instances now like the adoption last month of the Fostering Connections to Success and Increasing Adoptions Act of 2008 that will give states the option of keeping foster youth in care from 18 to 21, paid for in large part by federal dollars through Title IV-E. This gives states an opportunity to think differently about the 18-year-old delinquent if that person is in a foster care-like setting. What the availability of Medicaid for the 18 to 21-year-old comes into play as well for purposes of getting access to mental health treatment. There has to be different expectations around education for the delinquent youth, particularly around reentry, where too many of these youth are merely going to alternative schools for disruptive students or delinquent youth rather than having higher expectations. There are many more reentry programs now coming into play that are working to connect kids, but school districts are remarkably reluctant, and we need to find ways to get them to join us in programs that allow kids to receive credit for academic work that they did while in placement, and to give them opportunities to go on to college. We need to raise the expectations of the service providers. The courts themselves, I think, need to be multi-system in a way. Allegheny County in Pennsylvania has, for many years, had a dual status court. Every Monday, kids who are delinquent and dependent at the same time are brought before a single judge with their lawyers, caseworkers, probation officers, all working in service of one plan so that there aren't multiple hearings for the same child. This has turned out to be remarkably effective since the systems are not working at cross purposes with each other. Information sharing has to be addressed. This is a two-edged sword. It can facilitate services or it can do harm to kids as well. We have to be careful that it doesn't do harm. Information is often needed both for individual case planning and decision making, data collection and sharing for law, policy, and program development, and for program evaluation and performance measurement. But on the first, for individual case planning, information sharing has to have controls. There's a lot of hearsay in information, in child welfare files, in education files that kids and families are unaware of. And we need to make sure that information that it both informs evaluations and good practice doesn't do harm at the same time. And finally, I just want to mention the role of attorneys for delinquent youth and prosecutors here as well. Attorneys need to be making the argument that helps judges sort out who these kids are and helps define the youth for the court. This requires attorney access to much better evaluation and resources. And attorneys also have to share information with each other. The last time I was in New Jersey talking on this topic, dependent and delinquent attorneys, or attorneys for dependent and delinquent youth, said that they really couldn't talk to each other. That confidentiality protected them, prevented them from sharing information about their clients with each other in a way that I found remarkably bizarre for people representing the same client. And there are lots of ways around that in terms of consent. And you also can't have attorneys from different systems with different ethical responsibilities to the same client trying to maneuver across systems. And finally, prosecutors are an additional safety valve for the mislabeling of kids. Too many prosecutors process kids rather than make independent judgments about whether this is an appropriate child for the juvenile justice system. And there's more and better work to be done there as well. That's a quick survey of the terrain, which you will now go much deeper into. Joe.
Thank you. Next speaker is Joseph Ryan.
Great, thank you, and good morning, and thanks to our hosts for organizing such an interesting event. So I have a, is this a touch screen or no? Oh, okay. I'll just use this. Okay. How do I play the show? Great. Okay, perfect. So I'm going to talk a little bit about the research side to child welfare and juvenile justice involvement. I come to the university setting after several years as a caseworker on the child welfare side, and then about another 4 or 5 years as a clinician working in residential programs for adjudicated delinquents. So this topic and our subsequent discussion from folks in the field, I look forward to sort of help inform the research and see how we can create better partnerships so that research can help inform policy and practice. I'm going to talk a little bit about dually involved youth. There's a lot of terms around about this particular population of youth in Illinois, where I'm from. They use the term dually involved. In California, it's crossover. In the state of Washington, it's dual jurisdiction. Really the same thing. I'm going to be talking about youth who have an open and active child welfare case and that move into contact with the juvenile justice system. The connection between child welfare and juvenile justice, issues around child maltreatment and juvenile delinquency, are not a new area of interest. Jane Addams and her colleagues at the Settlement House in the late 1800s and early 1900s, and even the participants at the 1909 White House Conference on Dependent Children talked about the concern for dependency and delinquency issues and trying to separate these two populations. So I'll talk a little bit about the research then, where we are, what we know. There's about 4 decades of research, at least, around maltreatment and delinquency. And yet, we remarkably know not too much. And that's a problem for everyone involved. It's a problem for researchers, but it's certainly a problem for those interested in policy and practice. What we do know is maltreatment is associated with an increased risk of juvenile delinquency. This graph on the bottom is from Cook County, and it models delinquency rates over time. The top line represents youth with at least one substantiated allegation of maltreatment. The trend line on the bottom represents youth in the general population. And what you can see is sort of the trends follow similar patterns, as Larry had mentioned, sort of a declining delinquency rate during this period. So whatever is impacting delinquency in the general population is having an impact also for child welfare youth as well. The second finding that seems to be pretty consistent is placement instability increases the likelihood of delinquency. The more youth move around, and this is true in the child welfare system as well as in the general population, so residential mobility. But in the child welfare system, the more youth move between foster homes and group homes, foster homes and other residential providers, the likelihood of delinquency increases. Weak bonds with caregivers increases the risk of delinquency. So we did a study a few years ago in Chicago and Cook County that looked at youth reports of their attachments with their foster care providers. And those who reported low levels of attachment at sort of baseline, several months into foster care, had subsequently higher rates of delinquency. So these attachments that the youth have with perhaps important adults in their life being the foster care providers, important implications for the likelihood of subsequent involvement with the juvenile justice system. And then finally, child welfare youth more likely to experience detention, as Bob had mentioned, a New York City study looking at, the Vera Institute did a study looking at the likelihood of detention and higher for foster youth, which has implications for penetrating deeper parts of the child welfare system. So the focus of my presentation, I'll talk a little bit about some of our recent findings in this research. We've been working with Los Angeles County for the last 4 or 5 years to understand issues around dual involvement. This is a partnership with the University of Illinois, LA County Children's Court, a very sort of research-oriented presiding judge, Judge Mike Nash, and the Children's Law Center of Los Angeles. California is interesting in that until recently it was one of only a few states that youth could not be dually involved, that a child welfare case would be terminated and the case would move to juvenile justice. AB 129 passed a few years ago, and so counties are piloting different models to sort of how to best work with dually involved youth. And so it provided some opportunities for research to help inform this development rather than rolling out a particular program to study what we know about dual involvement and perhaps base policies and practices on evidence from LA County. I'm going to talk a little bit about the profile of youth involved in both systems. What do they look like? Do they look different than youth entering the juvenile justice system, not from the child welfare system? Placement effects, so mechanisms that may increase the likelihood of delinquency in the child welfare system. I'm going to focus particular attention on group home placements. And then subsequent pathways through the juvenile justice system. So despite 4 decades of research, we know virtually nothing about what happens after initial contact, what happens after the arrest. Where do these youth go? Do they follow similar pathways through the juvenile justice system relative to kids coming from other referral sources? And then priority areas for policy and practice. I'll finish with that. And I should say this is obviously not an issue just for California. I was just looking at the kids count from New Jersey brochure out front, and sure enough, a paragraph on the termination of child welfare cases and the movement of youth from child welfare to juvenile justice. So it's clearly an issue for every state and every locale. So in terms of who are these youth and are they different, we have a data sharing agreement with the LA County child welfare system as well as the probation system, 2 of the largest systems in the country, so and a very diverse system. So it provides us good opportunities for research. And so we have all the data from child welfare, all the data from juvenile justice, and as everyone knows, There's generally no unique identifier, so we go through this elaborate probabilistic matching procedures to figure out where the overlap exists. And what we find is that if we look at new arrests between 2002 and 2005, open child welfare cases account for 7% of all new arrests. So these are not cases that, this number would increase if you looked at, child welfare cases that were either recently closed or closed 10 years ago, and then they came back into the juvenile justice system. These are sort of open and active cases, and also only first-time offenders during this particular time period. What we find is they're about the same age in terms of their age at first offense, so similar in that regard. The big differences are around gender and race. 37% of the child welfare cases relative to 24% of the juvenile probation cases coming from different referral sources. And with regards to race, African Americans account for 46% of the child welfare, the sort of crossover population, relative to 21% in LA County. And put another way, child welfare accounts for 7% of all new arrests, yet they account for 12% of all girls entering the juvenile justice system, and they account for about 15% of all African Americans entering the juvenile justice system in LA County. So clearly contributors to overrepresentation, and perhaps Sean will talk a little bit about the issue of DMC a little bit later. So in terms of types of offenses, person-related offenses, violent, this includes simple assault, more likely for the child welfare system. And then also this threat-related offenses. These are threats against physical harm. I'll talk a little bit about those later, but those are also higher in LA County for child welfare youth. We also did a case file review, because this is administrative data. We're somewhat limited to what we can learn. But we did a case file review of 500 youth in a 6-month period that were open and active child welfare cases and moved to juvenile justice. We find about 55% have substance abuse and mental health issues, and only about 20% of these youth have received some sort of mental health or substance abuse treatment. Now, whether or not it's evidence-based, whether or not it's any sort of long-term program, but we have a population that reports about 50% in need and about 20% received services. So it raises some question about the match between needs and receipt of services on the child welfare end. In terms of the question around placement effects, so we merge our various data systems. The sort of bluish orb there, the circle represents the child welfare cases. So we pull out kids who are probably eligible for a delinquency petition or arrest, kids between 7 and 16 years of age in LA County, in placement, no prior arrests, and we have about 20,309 child welfare cases. We take about 82,000 of the probation records, and we look for the overlap. We find that there's about 2,100 youth in this sample that have some overlap in terms of their open placement cases, and they are then have contact with juvenile justice. Now, this overlap would certainly increase with time. This is a relatively short window, 2002 to 2005. So we have a very short period of time, and yet we still have about 10%. So what we want to do is figure out who these youth are. Who is this overlap? Are there certain placements or pathways that they've followed through the juvenile child welfare system that led to contact with the juvenile justice system? This will help inform issues, policy and practice issues around targeting. Who should we sort of be identifying and targeting our resources towards? The part of the problem with figuring out placement effects is that it's hard to disentangle individual youth effects from placement effects, right? If you think about foster care populations and group home populations, although they're similar kids, they're quite different in a lot of different ways, and they certainly are in LA County. So you can see there's two columns under foster care, 2 columns of estimates under group home. The one in the white represents sort of our pre-match. So if we have 20,000 youth in our child welfare sample, about 5,000 of those youth, about 20% have, 25% have at least one group home placement. And you can see that they are a bit different. Group home youth are a little bit younger in terms of age at first placement. more likely to be male, more likely to be African American, more likely to have the placement reason be for physical abuse. This AWOL, this is running away, so they've more likely run away from placement. They've more likely had placement changes due to behavioral problems. So in LA County, they record not only if children move, but also reasons for their movement. And you can see 26 versus 5% for arrests. These are subsequent arrests to placement. So we use propensity score matching to try to adjust for selection effects. And we match, since we have large samples, we essentially get a one-to-one match for as many kids as we can get to try to have a very good comparison group for foster home youth and group home youth. And the columns in the gold, yellowish, are the post-matched sample. And you can see that they're virtually identical on age of placement, male, race, and then reasons for placement change. You can still see some differences, obviously, in the arrest. So in terms of findings from this research around placement effects, so then we go ahead, we have our match sample, then we model the likelihood of subsequent involvement, the rates around that. And adolescents in group home placements are 2.5 times more likely to be arrested. So this is using the post-match sample, controlling for some of these other covariates that we matched on. And another important sort of issue is where these youth are at the time of arrest. So is sort of the pathway that youth are in a couple different foster homes, then they're in a group home for a relatively short period of time, then they go back to foster care, and then they're arrested. The implications for that would be very different than if a child goes from a foster home to a group home and then is arrested in a group home. What we find is when we look at all arrests, group homes account for 40% of all arrests. And these are, the offense doesn't happen in the group home per se, but the start and the stop date of that group home placement overlap with the arrest date. So what we seem to be finding is that youth move from a foster home to a group home and then subsequently are arrested, but before they leave the group home. They're also more likely to have a person-related offense, and then they're also more likely to have a threat-related offense, the group home individuals. And this is important in the sense that I'll get a little bit into this at the very end on the policy discussion. What are the mechanisms that are sort of increasing this risk around group homes? Group homes are clearly a target of interest because we're congregating high-risk youth together. They perhaps have less supervision. They see their siblings and their family less often. So there's some reason to believe that delinquency might be increased. But when we look at sort of the policy side, in Illinois, we looked at out-of-home placements, and we looked at their policy guides for what would trigger the contact of law enforcement. And in group homes, it was much lower than it is in family settings, not surprisingly, right? I mean, if you think about your own family setting, what would have to happen, what threshold would have to be reached to bring in law enforcement to resolve a conflict? Much lower in group homes. So the behaviors, to some extent, might not be that different, but the threshold, the policies on when to trigger the contact of law enforcement might put youth at greater risk simply because they're in that type of placement setting. And it's an important finding in the sense that it's something that's relatively easy to adjust. I mean, that is something that, through a standardized sort of policy on when agencies could engage law enforcement, somewhat simple to adjust. And then finally, what happens after initial arrest? So we look at, again, if you recall, the characteristics of youth entering the child welfare system are slightly different than that of kids coming from other referral sources. So what we do is we take first-time offenders and we match them to similar youth not coming from the child welfare system. And we match on things like age, race, gender, offense type, and number of charges, so that we have comparable youth. It wouldn't be a fair comparison if we're following foster youth through the child welfare system and other kids if they're coming in for different reasons. What we find is there's no difference with regard to the likelihood of case dismissal, about 25% in each. But we do find is there's significant differences with regard to the use of probation and placements. So there's really three options in LA County. Probation being by far and away the most likely option for first-time offenders, and this is really true everywhere. And then there's suitable placement, which is group homes largely, supervised by juvenile probation in LA County. And then there's correctional placements. This includes delinquency camps, and then at the very high end, a very smaller percent, is the California Youth Authority. And what we find is, regardless of controlling for age, race, number of charges, different types of offense, children coming to the juvenile justice system from the child welfare system significantly less likely to receive probation and significantly more likely to receive a group home placement, be suitable placements, or be pushed into the deeper ends in terms of correctional placements. Perhaps not entirely surprising, right? I mean, if you think about cases coming out of foster care or group homes, as Bob mentioned, in terms of showing up to even pick up youth, these are the referral sources. So they might not be as inclined to engage in the requirements for an in-home probation case. But certainly implications for how youth are being pushed into the deeper end of the system. And since we have a higher percentage of African American youth coming from the child welfare system, clearly impacts on issues of DMC at later points in the juvenile justice system. I guess those are two are mixed up. Child welfare, juvenile justice, priority areas for policy and practice, what I will finish with. There's really four, and Bob touched on several of these with his illustration that he opened with, but as well as a few other comments. The first is a need for systems that are integrated. And this has to do clearly with the sharing of administrative data, that one system can actually find whether or not this juvenile justice, this youth who appears before them for a delinquency petition, is actually involved in the juvenile justice system. This has a big impact on the issues around detention. The VERA Institute found that the foster youth were spending greater times in detention simply because no one knew they were in foster youth. They're waiting for a parent to come get them when in fact they're involved with another state agency. In terms of financing strategies that are coordinated across agencies, there's really significant obstacles to working with dually involved youth based on how finances are arranged. And I'll give you sort of a very simple example that I think will highlight the problem. I'm working with a detention center in Illinois, and they have a project for handling youth that move through the detention center, sort of a wraparound program that addresses some of the family issues, intending not to get these youth back into the juvenile justice system, back into detention. They screen out all the child welfare cases because the county's paying for it, and they assume that the state's picking up similar services for the child welfare youth. That's quite a leap of faith in terms of the assumption, but it certainly highlights the problems with financing structures in terms of having blended streams that can serve these youth and not worrying about whether it's coming out of the county budget for detention youth or the state budget for child welfare youth. Practice models that are clearly articulated and have empirical support. Continuity of representation for youth. Some of the issues that Bob had raised around having a continuity even in the judges in these courtrooms that hear the same cases. So it's not a different case, a different judge for the child welfare, a different judge for the juvenile justice, and when they finish, they move back to child welfare. Cross-training for practitioners. Right now we sort of have two separate professional training routes for folks interested in working with juvenile justice population and folks working with child welfare populations. Even in our school of social work, training professional social workers to work in group settings. A lot of these kids are in group settings, yet a lot of our professional training is geared towards individuals. And it's a very different dynamic than working in group care settings, which about 25% of these youth end up in. And then in terms of an investment in research and evaluation, we need to better understand the mechanisms and the pathways that connect child maltreatment, child abuse and neglect to subsequent delinquency, if in fact we're going to do anything about it on the policy and practice end, right? What is it about particular placements? What is it about even placement instability that increases the risk of subsequent juvenile justice involvement? Without really knowing those mechanisms, it's nearly impossible, or it is impossible, to guide policy and practice. And I say this because there's probably not a state or locale in the country that's not working towards integrated systems for child welfare and juvenile justice youth. And yet, we have no sort of research helping to inform this practice. And it's not that the ideas that practitioners in the field have gathered over the years are not sufficient, but it would be nice to have some sort of research component helping to inform what system is best equipped to deal with these youth. And that's all I have. So we'll turn it over to Tom to talk a little bit about the mental health and juvenile justice.
Thank you.
I spent the last 2 days driving around Indiana and Illinois. We were, with some research assistants, we were enrolling detention centers, 2 or 3 of them, for a research study that we're doing on mental health screening. And yesterday morning, actually, we were in one of those detention centers and talking to the director, and were interrupted around 9 o'clock. And the director went out of the room, came in 5 minutes later, said there was a police. They were asking my permission to bring a youth to detention, although they're really not charging the youth with anything. The youth was found walking down the middle of an interstate highway with a can of something flammable in one hand that he was drinking, and a very sharp, heavy plastic object in the other hand with which he was cutting gashes in his chest. They'd already called the mental health system, ER, and couldn't find a bed right at the time. And they were hoping that the detention center would take the youth. As we were driving to the Indianapolis airport, one of our research assistants got a cell phone call from a detention center in another state where we were already starting the study. And they have a way of coding mental health events as they occur in daily activity in the detention centers. They were having trouble coding one of the events that they had just had. It's a girl who was there in the detention center for a very serious assault against another girl. And the event was that when they woke up in the morning there in the detention center and got her out of her room, they found that she had pulled out most of her hair and eaten a substantial quantity of it. Okay, now this is serious stuff. It's the serious and deepest end of a broader issue that we've become much more attuned to over the last several years regarding mental health problems of kids in juvenile justice system, and the fact that many of those kids are overlaps with regard to the kids that mental health systems have or should be treating and dealing with. As Bob's already pointed out, too often our services are set up as though youth either belong to juvenile justice or to the mental health system, which doesn't really reflect reality in terms of child development and children's and families' problems. So my comments are going to describe some research and a substantial amount of clinical evidence, actually, that may help in shaping some kind of a policy, a public policy that addresses some of these issues. I won't end up in very much, in fact, I'll end up right there, right where Joe did, okay? So you can just leave the PowerPoints right there. That's where I'll end. Larry very nicely described the pendulum swing that's happened in the last 10 to 12 years. And attention to kids' mental health problems in juvenile justice has been part of that pendulum swing. It's been substantially accelerated and promoted and made obvious by a number of very, very good research studies in the late 90s and early part of this century. Linda Teplin and a number of other people whose data have been pretty consistent in terms of their findings. The consistent finding is that about 2 out of 3 youth in juvenile justice settings meet criteria for 1 or more mental disorders. That's compared to about 2 in 10 if you were in the general population. Substance use, roughly 50%. Disruptive behavior disorders, about 40%. Anxiety disorders and PTSD, anywhere from 25 to 40%. Mood disorders, 25%, and so forth. And many of these are comorbid. There are many youth that show more than one. If you take conduct disorder and say, well, that's not really a psychiatric disorder, let's kind of put that aside. It doesn't matter because 85% of those kids are meeting criteria for some other psychiatric disorder also. Does that mean that 2 in 3 of these youth need treatment? That they need treatment right now, clinical treatment, psychiatric treatment? No, it doesn't. There's a great variety among youth who meet criteria for disorder regarding the severity of their symptoms or the temporariness versus persistence of their disorders. Kids' disorders are very variable compared to adults, coming and going across time. It's not that we need to be providing psychiatric treatment for 2 out of 3 kids as they come into the system. But there is certainly a core that these studies are identifying of youth that are persistently, have persistent mental disorders and persistent mental health problems that have begun in their childhood, are carrying on through adolescence, and are likely to go on into their adulthood. That's perhaps 2 out of 10 in juvenile justice settings, and there are some that we would be most concerned about, but we can't ignore the rest because many of those who are having temporary kinds of psychiatric symptoms are very serious and acute at the moment, as in suicide situations. That's the kinds of problems that we're talking about. Why do we find mental health problems with such frequency in juvenile justice settings? Well, I think there's a couple of different primary reasons. There's a theoretical and empirical relation between mental disorders and aggression and violence. Many disorders of adolescence include things that increase the risk. Depression in kids frequently manifests as anger. Anger causes other people to react to the youth in particular ways and increases the likelihood that something aggressive is going to happen. ADHD and impulsiveness, trauma, and whoever used the example of the youth who was touched and react like a knee-jerk. This is a thing you find with kids, some kids with PTSD, who overreact to otherwise not so harmful situations. You put this together with the fact that adolescence in general, as is a message of rethinking juvenile justice, there's your second plug for the day, right? There you go, hold it up. You have to put all this on top of the fact that adolescents themselves ordinarily and on average are still developing impulse control capacities and their ability to think out things in the long run. And you have a situation where having a mental disorder in adolescence increases the likelihood that you're going to do something that could get you arrested and therefore find yourself in juvenile justice. Now, does that mean that delinquency and aggression are due to kids' mental disorders? Well, certainly not. If you get out of the juvenile justice system, you do studies in the general population, what you find is that, for instance, about 30% of youth with persistent mental disorders are also persistently delinquent. Or turn it on its head. Among the youth who are persistently delinquent, about 15% have persistent mental disorders. It's only part of the problem. If you treat kids in the system for their symptoms, yes, it'll reduce the risk kid by kid, but it's not going to have a massive effect on aggression and delinquency. It's something that you can argue the system needs to be doing for public safety purposes, but there are dangers in the statistics. For instance, if the public generally thinks, oh, all of this means that kids with mental disorders are dangerous, or all of our delinquency is due to mental disorders, and that's something we need to try to avoid as we move this message along. The second reason that you find so many kids in the system with mental disorders is that we think it's because, in part, that the community mental health system for kids has failed our children over the last 15 years or so. That during the 1900s there was a deterioration of child mental health services in the community, generally, in most states. Outpatient services decreased. There was the virtual disappearance of emergency beds for kids in many communities. And that this not only may have contributed to delinquency, but the main problem has been that the communities have responded to poor mental health services by using the juvenile justice system as an alternative. So now we're back to my original story about the kid walking on the interstate. The director of that detention center said, no, we will not take this youth. I was impressed because many detention center directors would take that youth, especially since this particular detention center was paid by the case. So, you know, it was, they would get funding for that. But this director said, no, you can't put kids in detention without a charge. And you might find a charge for this kid, but, and if you do, I guess I'll have to take them. But basically was resisting the thing that's happening all over the country of communities using the juvenile justice system as the way to get services that they can't otherwise get in the community, that parents can't get. Parents are calling police to get their kid arrested so that their kid can get services that they should be able to get in the community without criminalizing the kid. This is a very key picture that is been playing out and and really begins to especially highlight the relationship between those two agencies, child mental health and juvenile justice, and the misuse of juvenile justice to do things that the community mental health system ought to be doing. Now, what does all this say for policy and practice? Well, it produces a sort of a mixed message. On the one hand, there's a clear need for juvenile justice to attend to kids' mental health problems when they are arrested for serious offenses and they require custody. On the other hand, if we put increasing dollars into treatment services in juvenile justice, we're risking the very things that I was just describing, of turning the juvenile justice system into the community's mental health system and requiring the kids first offend and then get arrested and then get a record in order to get services that they should be able to get in the community. And the answer so the answer is not simply to increase treatment services in juvenile justice. Specifically, here's some things that we think the juvenile justice system ought to be responsible for. But whatever it is, it should be focused and it should be limited. For instance, identifying kids as they come into the system. Obviously, if kids are coming into the system with mental disorders, the juvenile justice system has an obligation to identify who they are, especially to respond to emergency kinds of things and crises, suicide crises, and making sure that those youth get further assessment if they are seriously disordered. Developing adequate mental health assessment services. That is, when you screen a youth or screen youth for mental health problems, you do identify kids who may have longer-term problems, a way to send those kids to clinicians who can do assessments so that when those youth are adjudicated, their dispositions include something other than simply being locked up, something that puts treatment in their dispositional plan. Some communities have very nicely developed systems for that. Their juvenile courts have their own juvenile court clinics where there are clinicians who can do those evaluations, give them to the judge to be used in dispositional planning and so forth, and others do not. There are a variety of kinds of models for it, but those themselves actually have not been well studied, and we need considerable more research on the best way to provide that kind of an assessment service. For kids who are adjudicated delinquent who have mental health problems, very obviously what we need to be doing is to be using evidence-based practices with regard to their rehabilitation and their treatment, of which we have research that suggests there are many, even though, as Bob, I believe it was Bob indicated, many communities are not using those yet. Or that was Larry who was talking about the fact that we have these services, but frequently communities are not actually making use of them. One thing we have to remember is that juvenile justice is not sometimes a particularly good place to be doing clinical treatment. This is an yes, it's for child welfare, but it's an adversarial system as well. And in a very broad general way, most therapies, no matter what they are, require a relationship of trust between the person doing the treating and the person receiving it. And it's not that that can't be generated in a juvenile justice setting, it's just harder in terms of the total atmosphere of most juvenile justice settings. Sometimes treatments that are applied in juvenile justice custodial settings work fairly well in the setting, and as soon as the youth is in the community, the effects wear off, so to speak. Behavior modification kinds of activities, for instance, work quite well in some institutions. Put the youth into the community, and the contingencies that were surrounded that are no longer there, and they don't work so well. So, you know, it's further argument that while certain kinds of treatment in a limited sort of way are definitely needed for kids who are in the juvenile justice system, our better approach is to not put all the money there, but to actually be beefing up community mental health child services. And then, of course, this. Working on ways that juvenile justice and mental health and community mental health can collaborate. With regard to information sharing, with regard to financing, with regard to collaboration, develop aftercare programs where kids coming out of juvenile justice don't just have a probation officer. They have a team of people, one from education, one from child welfare, one from juvenile justice, and one from mental health, who provide wraparound services. Now, there are many communities that have developed these sorts of things. On the other hand, the vast majority of communities have not. I suspect that, and because there are so many political barriers to the trying to blend the money, trying to blend the services, that one wonders whether this really isn't going to be resolved until some reorganization of community agencies is developed, such that there is a child agency that can increase the capacities for blending services that make sense for kids. So that's there's promise there. There's really not enough research. There's some research, but not enough to demonstrate these various approaches to blending services, but they're clearly the direction that almost everybody thinks we ought to be going. Thank you.
We have some time for questions. I'm seeing the two mics down here. Is it the intention to have people who have questions to come down to the microphones?
We'll bring the mics to them.
Okay. Are there any questions, comments? Gentleman right up here.
Thank you for a very informative panel. I was struck when Cecile introduced the panel. She mentioned several systems. one of which was education, which was hardly mentioned at all in the discussion of the panelists. And I recognize that one can't discuss everything. But it seems to me that education is clearly the system in which children have the most contact and which is most well funded. And while I could address probably the question of any of the panelists, to Dr. Grisso, it seems to me that the mental health issues, both prior to contact with the juvenile justice system and following release from the juvenile justice system, that education can play a powerful role. And I know our special education system is misused, but it does in many, many, many cases provide help for these children that you're talking about. And I was wondering what your thoughts are in terms of prevention and aftercare being utilized through the resources of the education system.
Is this going to work?
I think the mic's working. Yes.
Yeah. Okay. Yes, the one you probably did pick up, the one comment I made near the end about aftercare, that there are aftercare systems that are bringing, and education has got to be part of that aftercare package, a person from education devoted to it. But going to the front end of this, the preventive end, I have been learning experientially over the last year or two that a lot is going on out there innovatively regarding truancy programs, for instance, that blend educational programs and child welfare and, interestingly, juvenile justice. That is, many of these truancy programs in some of the states that I'm working in are run by prosecutors' offices as preventive activities to get it. Now, one of the things that one needs to be careful about with those systems is that in some instances I see them actually sucking kids into the juvenile justice system. It depends on how that truancy program is used. And if it's used in particular kinds of ways, you can be identifying kids early on and getting them services that will avoid that. But then if you've got a system where if they fail to comply with the truancy program, it's a violation that allows for adjudication, you're simply increasing you're priming the pipeline to get those kids into juvenile justice. That's just one of the issues that I've noticed that we're having to work on. But overall, the truancy programs that I've seen have promise that they can avoid those kinds of things, and mainly need research because there's very, very little out there on how to do those, in an evidence-based practice way as to how to do those things right.
I just want to mention something about reentry. The structure of the state juvenile justice system and child welfare system is very different than the school system. There are far more school systems. There are far more schools. Local control is the byword in every state for education. So one of the things we're trying in Pennsylvania now through some MacArthur-funded work is we got our State Department of Education to create a freestanding position without portfolio, in a sense, for someone responsible for juvenile justice issues and data collection to try to see about reentry, continuity of special education programs, IEP. It just started in the last year. But we were stymied by a state system, which would be here in Trenton, that was organized around preschool, elementary ed, higher ed, and the like, but no focus on the populations that we're talking about today, nor with any authority to regulate reentry of kids, so that each school district and every school was funneling or channeling kids out of mainstream education. We're also trying something around credit transfer issues. Through a project that has multiple funding sources, including from our state advisory group, that has poured money into a Pittsburgh-Philadelphia collaborative, because they account for about 40% of the kids in placement, to change what's happening in placement agencies that have the large numbers of kids so that their curricula would be aligned with state standards and increase the chance that when a kid studied algebra in my residential treatment program, that he or she would get credit for it when they return to school. And there are other things that could be done to create continuity there that are happening. And unfortunately, they would take the rest of the day to get to it, but I'll be happy to chat with you at lunch.
Another question? Down here? Oh, you're going up there? Okay. Yes. Sorry, I will take your question.
Thank you, panel. Very interesting. I have a question, and my colleague has a question. I suspect to Dr. What's his name, right? Dr. Steinberg, because your emphasis was on, I really emphasized on your last point you made between differentiating between fact and opinion and applying different curriculums or how we approach these issues. I have a question that you might be best targeted towards you, but at what level of impact do you think or hope the community-based, in particular faith-based organizations can play in this problem concerning curriculums that are empirically based, where someone else it may apply, but have you seen any models with this that have been effective? Because I know with government, they're trying to utilize, when you talk about community-based programs, also including those faith-based organizations. Do you think that's a viable relationship, and how do you think success is there?
Sure. I think that the fundamental concern seems to me what's being delivered as a treatment or an intervention, not who's doing the delivery of it. And so if we know, for example, that something like functional family therapy is an effective intervention for antisocial kids, it doesn't seem to me to matter very much whether we get kids into that through their association with faith-based organizations or whether it's through their association with a government agency. So I don't think there's anything magical about the government providing services. I don't think there's anything magical about faith-based agencies providing services. What I do think is important is that whoever the service provider is, or in some cases the service facilitator, that the service be one that has some empirical evidence in support of it.
To follow, thank you. Are you familiar with any models out there like that are using those empirical-based curriculums that are being effective?
I'm not. I mean, that's not really my area of expertise. But again, I think if you look at there are several good analyses out there. Not only Peter Greenwood's that I mentioned, but Mark Lipsy's and a couple others that really look at the evidence for very different types of programs, whether they're family-based or individual therapeutic programs or work programs or education-based programs. And so I think that we can provide a menu of options that agencies, both private and public, can draw from in trying to best meet the needs of their clientele.
Okay. I think we had a question down here, and then we'll come back up there.
I think I actually have two questions that I see as two sides of the same coin in some ways. It appears to me that over the last 5 to 10 years, we have dramatically changed and escalated the way we treat juvenile sexual offenders, and that things that were at one point not prosecuted now are prosecuted with a great deal more repercussions for the juvenile. And I'm wondering if you could talk a little bit, whoever feels that it's applicable, about how the system treating these children differently? Does it have programs to treat them differently? And the other aspect of that is that down the road, it also appears to me that the adult offenders often have the contact that they've had with the juvenile system often has involved sexual assaults either within the system or from other adults. And are the children within this system afforded particular assistance for sexual assaults? Because I haven't heard anything about that, and yet down the road it tends to become an issue for adult offenders.
You want to take that?
Yeah, well, ultimately, the answer to the question may be different from community to community. You have to, there's different kinds of services in different kinds of places. The most basic things that we think we're finding out about kids who are adjudicated with sex offenses is, number one, they are not a type of kid. There are kids who are adjudicated for all kinds of different sorts of sex offenses, and that there probably is no treatment for sex offenders, juvenile sex offenders. It's a fake group. We shouldn't even be thinking about them that way. That most kids who have gotten adjudicated for sex offenses probably should receive no treatment. There's nothing about them characterologically that makes them any different from the kids sitting next to them in the schoolroom. There certainly are juvenile serious sex offenders who do have persistent long-term problems that need to be treated, but they're a very small proportion. We know that the recidivism rate for kids who are adjudicated with sex offenses is extraordinarily low, less than 10%, I believe, and much lower than for adults. And that's because the mere fact that they've been adjudicated for a sex offense doesn't say very much about them, their mental health problems, who they are characterologically, and so forth. These are some of the controversies and that are behind it. I mean, they're sitting alongside that are a group of people who say we need to be treating all these kids who have sex offenses. They all need to be in special programs. So my view is one view, okay, and there are others. Basically, though, I think the appropriate referral is to Frank Zimmering's book. Remind me. American Travesty.
An American Travesty by Frank Zimmering.
Yeah, which is all about that. Okay, it's what do we really know criminologically, clinically, legally, about kids who are being arrested and charged and convicted of sex offenses. And some of these things that I'm expressing are Frank's views as well, based on really, really good review of the research.
The only thing I would add, and without getting to your second question, about which I know very little, is that the Federal Sex Offender Notification and Registration Act, also known as the Adam Walsh Act, is requiring states to create registries that are not quite as individualized. There's a one-size-fits-all approach. Or two sizes, because you could be on the registry for 25 years or life, depending on your category. And there are ways for states to say that they have tried to comply but have failed because of their own state laws or constitutional provisions. But right now, most states are getting their laws into place. And I don't know really how New Jersey has approached that, but that's something that should be of concern here.
Okay. Question up there.
Hi. I have a question about the arrest, the youth arrest with the group home. I just wanted to know if there was a significant difference between the arrest youth versus, the arrest that youth have, whether they're adopted versus being in the group home or foster care. I know that you talked about, like the parent relationship with the parent-child relationship. Is it just the instability, or is it the fact that, the youth knows that they're not with a real parent? Does that affect whether, they're arrested or not? So I wanted to know if there was any other research besides the group home and foster care.
Well, there isn't really too much around the mechanisms in the child welfare system. The issue of adoption is sort of after they leave the child welfare system. And so some of this research focuses more on understanding what it is about their experiences in the foster care system. But clearly, as you note, the relationships they have with positive adults, like their foster care providers, be that relatives or non-relatives, impacts their likelihood of offending and getting tied up with the juvenile justice system.
Other questions? Right here.
It was interesting to look, Joseph, at the Cook County delinquency filings. It appeared to me, and I may be incorrect, but it looked like since 1995 there's been actually a half of the filings, so that we've seen some real improvement in a decrease in the filings. And I wonder if you could comment on that. And the second thing is more of a question, because I think in some states, and especially here now in New Jersey, child welfare is taking on a little different role. Child welfare being defined in terms of the Division of Youth and Family Services as being involved with neglect and abuse cases, and if it's not neglect and abuse, it goes someplace else in terms of the silo system. So I just wanted to make that comment.
Yeah, I mean, I think that the decline represents and mirrors the national decline during that same time period. So I don't think there's anything particular unique that's going on in Cook County. Those delinquency petitions, I think, were going down during that same time period everywhere. On the second point, child welfare system on taking different cases, taking on a different role, that's true as well. Illinois passed legislation a couple months ago that when juvenile offenders come in, I think it was between 13 and 15 years old, they can be screened for essentially child welfare issues and maybe sent to child welfare if in fact they find it a better system to serve the youth rather than dumping them in the juvenile justice system. So clearly, like the schools who are always taking on more and more issues, child welfare seems to be headed in that direction as well.
Question there.
I have a question for each of Professor Ryan and Professor Grisso. Professor Ryan, did you do any measurements of the rates of detention between the two groups? Because Los Angeles County historically has had a very high detention rate, and it's possible that whether that was reflected, because historically the kids who are most in need of some kind of a family have the ones who've gotten the short end of the juvenile justice stick, and their rates of detention have always been higher. The question for Dr. Grisso is, your jurisdiction of Massachusetts has had something since about 1910-15, the Judge Baker Clinic, which was supposed to provide this mental health assessment. And I just wonder what happened to it historically, and what does that tell us about what mental health might be doing in terms of the court?
Professor Ryan first.
We haven't done that. Before we got involved with LA County, they had looked at that, and they really had looked at that because the Vera Institute in New York had come up with this Project Confirm, a way of showing that detention rates were higher for foster care youth and coming up with a relatively simple solution to address that. And so LA County had already embarked on that by the time we had gotten there. They called it Project Confirm West, I believe. But yes, as in New York and other jurisdictions, detention rates were higher for foster care youth, as were bench warrants. So there's some of these probation violations as well. As Bob mentioned, the representation getting kids to and from hearings is often a problem for foster care youth. So those things are contributing to detention rates as well.
Dr. Grisso.
I wish I had 5 or 10 minutes to give you a little. You don't hear much about these juvenile court clinical services any place. For those of you who are interested, when the juvenile court was started in Chicago, Cook County, in 1899, just a few years later, there was a juvenile court clinic developed called the Juvenile Psychopathic Institute. Terrible name, but Healy and Fernald staffed that. And developed what they called child studies. And they would do evaluations, but they were really comprehensive developmental clinical studies of kids that they would give to the judges who would use them in their dispositions. They took that model to Boston, the Judge Baker Clinic, I think about 1925, maybe a little earlier. And that still exists, although it's not called the Judge Baker Clinic anymore. Those services are actually in the juvenile court clinic in Boston. Massachusetts, over the years, then adopted the practice of having juvenile court clinicians in every juvenile court, in all 17 juvenile courts in the state. And that's the way things are now. And indeed, the state contracts with my program, the Law and Psychiatry program at UMass, to provide the quality control for that. So we certify the clinicians in those juvenile court clinics and train them, give them continuing education, written exams, and so forth. That is the most elaborate juvenile court clinic system in the United States, in the one in Massachusetts right now. We've done a national survey about 4 years ago of the 100 largest juvenile court jurisdictions in the country as to how they get these evaluations of kids for their judges. About 40% of those jurisdictions use that juvenile court clinic model, somehow having a clinician, full or part-time, or in large courts, many clinicians who just do that. Other communities use community mental health centers, so that when the judge wants an evaluation, they go to the forensic person in the community mental health center, the child CMH. And a substantial proportion, about a third, use private practitioners. So that the judge has or the clerk has a roster of private clinicians who will take cases from time to time. We don't have very much research on comparing those models, but I have some reason to favor that, besides the fact that I'm in Massachusetts, I have some reason to favor that juvenile court clinic model. Private practitioner model gets a little fragmented. More than you probably wanted to take time on here, but it's one of my favorite topics.
Susan?
Hi, thank you both. I just wanted to ask actually either one or both of you if you could comment on the usefulness of the concept of complex trauma to understand many of the kids, particularly the kids coming out of the child welfare system. Because I noticed that Dr. Grisso talked about PTSD, but complex trauma really covers a much larger kind of category of behaviors. And I'm not sure how much that's been attended to in any of the treatment programs.
You know, I actually, yes, trauma is to talk about it, we need a little bit more time than we've got. It's extraordinarily important and almost a clinical connection between child welfare and juvenile justice, and that's why it's so interesting. I actually bet that Beth Kaufman's going to talk some about that this afternoon in her girls section. Okay.
But it's not just girls.
But it's not just a girls' topic. We know, in terms of my perspective on these things, in terms of the research, we know that the issue of trauma is as substantial virtually for boys as for girls, and plays a role in delinquency, kind of like the one I was describing, that it increases the risk so much of kids' aggression. But we'll wait and see what Beth has to say rather than stretch this out.
And in terms of on the child welfare side, not to split hairs, but I've never been able to fully figure out the difference between the complex traumas and the simple trauma. The youth in the child welfare system certainly have had both, if there are a distinction between them, if there is a distinction between them. But the vast majority don't end up in the juvenile justice system. And we don't really know much about what it is about the particular trauma that might lead one to engage in delinquency.
Well, if I could just add one thing. As I understand the literature on complex trauma, there's a big emphasis not just on the trauma, but on the attachment disruption, so that when you have trauma occurring continuously in the child caregiving system, which is what child abuse is, you're likely to have complex trauma. And I did note in your presentation this thing about kids who had trouble attaching to a caregiver were more likely to end up. So, I mean, I think it's a very related concept. That's why I'm raising it.
Oh, right. Oh, the relationship stuff that we do more looks at their social bonds, so their strengths of their bonds. with their individuals and also with institutions. So school being one, religious organizations being another, sort of these, how we associate with individuals and institutions, but not so much on disruptions and attachment early on, and then their relationship with offending later.
Okay. We have time probably for one more question. Preempted the question.
Joe, I was interested in your comparison of group homes versus foster homes. Seemed to be a big differentiation. Can you talk a little bit about the cost element of one versus the other? And does that drive people to assign people to that area as opposed to another? Or is it simply that we don't have enough foster parents?
The costs actually are quite dramatic. I don't know if anyone here works in budgeting for New Jersey and could say what the costs are here. But they could be, a foster care payment could be several hundred a month for a family, depending on their needs. And a residential care facility, group home, smaller or larger otherwise, could be several hundred a day. So you would think the costs would drive them towards family care. And that really does explain why we try to figure out the selection process in comparing them, because these kids didn't sort of randomly end up there. It's not, if they have a foster home and, least restrictive is always preferred. But those are not always available, either just because of lack of foster homes, children running away from homes, running away from enough homes, or foster parents saying, this isn't really what I signed on for. This is a more difficult case. But the costs are dramatic between the two different types of services. And so really group homes are generally used as a means of last resort, but not all the time.
All things being equal, you would send someone to a foster home.
Right.
Okay.
I think the evidence points that children raised in home environments rather than sort of congregate care environments seems to produce better outcomes.
Okay, we've gone a couple of minutes over. Please join me in thanking this panel.